Hello, everybody. Sorry, we were just chatting over there, not realizing at all what time it was. And then Dr. Deal was like, you guys can start. It's several minutes past. So can everybody hear me okay? I'll try and stay close. My name is Kelly Larson. I am counsel for the department. I'm one of many. I do a lot of work with PACVA, a lot of work with BAP. I'm relatively new to BAP, not to PACVA. So I'm not sure how many of you I have met or seen. I'm not seeing very many familiar faces, so hello. Thanks for coming. I think this is mandatory, right? I'm not sure if it is or not, but I know it's the same presentation that you guys have seen year in and year out, so bear with me. I think we got to just kind of slog through it. I was telling Claire, Dr. Vaden, that the good news and bad news that you guys have authorities that are so clear and that are so specific is that there's less ambiguity, but the bad news is it doesn't really lend itself to a presentation that's easily varied or made more interesting. So bear with me on this one. I want you to feel free to ask any questions and just kind of throw up your hand if I'm talking about something that you feel like there isn't as much clarity on, or that you could somehow, you want to discuss. Anything, just throw it out there. You guys obviously have quite a bit more experience than my last group, so I imagine you have lots of examples or thoughts, and I would love to hear from you. So please just raise your hand or shout out if I don't see you. So as I mentioned, your authorities are pretty specific. They're mostly in statute. There's a little bit in Part 2 of the rules, but those mirror the statute as they should. So the statute is generally speaking going to be your best source of information. The overall purpose of the act, I know you all know this, but the General Assembly hereby finds and declares that the protection of companion animals and livestock is a matter of statewide concern. Policy of this state is that persons responsible for the care and custody of such animals be persons fit to adequately provide for the health and well-being. That means the focus is mostly on 3542-109, which prohibits the mistreatment or neglect of any animal to such a degree that it endangers their life or health, and certainly abandonment in any case. As you know, there are 5 distinct categories of agents. Each of these categories is represented here today, and each of these categories has unique limitations as to their authority and the scope of their abilities. I think most of you, well, I shouldn't say that, never mind. The authorities that may be conducted without law enforcement or CDA involvement include civil investigations, criminal investigations, at least as to misdemeanors, entry and care in terms of providing food and water, intervening to prevent mistreatment, neglect, abandonment, or cruelty, and in some very limited circumstances, euthanasia. The goal when it comes to investigations is to gather facts and evidence to determine whether probable cause or PC exists. In the criminal context, we always operate under the assumption that somebody is innocent until proven guilty. Very similarly, in the civil context, we operate under the assumption that there is no violation unless and until we have sufficient evidence that there is a violation. Your day-to-day role is going to be to interview witnesses, make observations, and when I say observations, I mean get creative. Anything that you see, anything that you hear. I had a case with Dr. Vaden in which she opined in the process of essentially entering and providing food and water to an animal that she smelled what she knew to be, in her experience and training, infection. So I think it was the breath of this particular animal indicated there definitely had to be some sort of dental issue. That is an observation that is very important as far as the fact-finding and investigatory process. Take pictures. I don't know if you all have cameras, body cams, or just on your phone, but video coverage is very, very helpful. Obviously, you want to document any and all findings in your written reports, and you do have the ability to get an administrative search warrant when you are working with CDA. There's obviously a very important distinction, I know you all know this, between livestock and companion animals. Not all agents are authorized to investigate livestock. For those of you who are not CDA employees or sheriffs or appointees of sheriffs within your own jurisdiction, you may not investigate cases involving livestock. But keep in mind as well that not all livestock matters have to fall under the title of investigations. And we'll discuss this in the context of food and water next. So entry and care, providing food and water to any animal that is found to be without water. Except as authorized by law, no animal, and that's an important distinction. We're not talking about just livestock versus companion animals. It's any animals, which is very broadly defined under statute, shall be confined without an adequate supply of food and water. Again, the definition of animal is very broad. Really, the only restrictions you have in this setting is that you may not enter a person's residence, and you must post notice of entry and care upon leaving an area or building where the animal is confined. In the case of companion animals, 72 hours without food or water by anyone other than the agent, vet, or peace officer constitutes abandonment. And abandonment is a violation of the law. It's 3542-109 and permits you to issue a criminal summons and complaint for misdemeanor animal cruelty, to engage law enforcement, and or to refer to the BAP program. These options are not exclusive, so you may do any one of them, all of them, a combination of them, whatever is appropriate. It'll be very fact-specific. And in my last presentation, I had somebody ask me if the 72-hour limitation was statewide or specific to jurisdiction, and that particular officer was working for a municipality, and so under her particular municipality, it was 24 hours. So be mindful that there may be other requirements specific to you in your jurisdiction that need to be followed. And obviously, if you're talking about abandonment of livestock, you need to engage local law enforcement. So interference to prevent mistreatment, neglect, abandonment, or cruelty. This is kind of a tricky one. The statute, the plain language, allows you to lawfully interfere to prevent the perpetration of an act of mistreatment, neglect, abandonment, or cruelty, which occurs in your presence. I imagine that doesn't happen very often. Is this something that you guys have seen happen a lot? It sounds like no. If and when it does happen, again, this is pretty tricky because while you can lawfully interfere or prevent it, you need to do so without subjecting yourself to harm or taking unnecessary risk. And you do have somewhat, was that a hand? Sorry. Okay. And somewhat limited authority. So your best option here is to de-escalate or do the best that you can to de-escalate unless you are law enforcement. You don't have the authority to take the animal or arrest the person. You may or may not be armed, and again, we don't really even want to get to that point. So the best option is to de-escalate, consider calling law enforcement, and continue to observe and document what you can, photograph, unless you think taking photographs is going to incite more trouble than it's worth. Finally, also, you do have the ability to create or effect euthanasia. That's true for any agent of the Bureau or peace officer. They may lawfully euthanize or cause to be euthanized any animal in his or her charge when. And it's very narrow. It's very specific circumstances. In the judgment of such agent or peace officer, and in the opinion of a licensed vet, the animal is experiencing extreme pain, suffering, or is severely injured, disabled, or diseased past recovery. And then there's another exception if a vet is unavailable. Again, it's pretty specific. You need a written certificate of 2 persons, one of whom may be selected by the owner if the owner so requests. Called to view the animal in the presence of the agent. The animal appears to be, again, severely injured, diseased, or disabled, past recovery. So the bottom line when it comes to euthanasia is that the best practice is to leave it to the experts. If for some reason the facts absolutely dictate that you euthanize an animal, you have to follow exactly the statutory instructions that were just on the previous slide. And it's best practice to ensure that the Department of Ag knows immediately or as soon as possible that this has happened. In the last presentation, I asked if anybody had to effect euthanasia, and a volunteer offered that she had been on a case that needed it to happen. It absolutely was a vicious, I think, or dangerous dog, maybe, and had attacked its owner. And so a police officer, in an effort to euthanize the dog, shot the dog. It didn't kill the dog. So, and that's what we're trying to avoid, specifically, is inducing additional suffering and making a situation potentially worse. So best practice takeaway is to leave it to the experts if you can. I know that's not always easy. Has anybody here had to effect euthanasia, had an experience with it, good, bad? Probably not good, but neutral, bad? Do you mind sharing it with us?
Yeah, I had one actually it was last Friday. I obviously did not perform the euthanasia, but I had to go down south because there was a report of a horse that maybe was thin. That was all we had.
Was maybe thin, I'm sorry?
Yeah.
Yeah.
I'm the. Okay. The only information that we had was that this horse was possibly a little thin, and that was all we had. So, I mean, you go to a property trying to expect the worst and maybe nothing at the same time.
Right.
But we got down there, we saw the horse, and we were like, oh, she's not, super thin. She is underweight, but this seems manageable, something we can work with. But the closer we got, we found out that she had some really severe neurological problems to the point where it was affecting her ability to walk, as well as she had a really old injury to one of her back legs, which caused her to walk basically on like the heel. So in her hoof had grown out about 1 foot long, just straight. So we tried what we could, but that was a case where we went down kind of not expecting too much, but by the end of the day, when we couldn't get a vet to come out, so she was able to be trailered a really short distance, but we did have to take her to the vet for the owner to have her euthanized that day. So
Okay.
that was terrible.
Yeah, it does. That sounds terrible. But the right outcome and the right procedure, certainly. So thank you. So I figured we'd try and kind of walk and talk through a hypothetical. We can change it as we go. But the hypothetical is that an anonymous complaint comes in about sheep in Grand County that have been confined in dangerous enclosures that are too small, animals unable to lie down, turn around, engage in species-appropriate behaviors. There's no shelter from the elements. It's wintertime in Grand County. No food and water. So the program manager asks if a BAP agent who's employed by a nonprofit can drive to Grand County and investigate. So the question is that permitted? And what's relevant here, or what's important to keep in mind, take note of, is that what kind of animal is it? It's a sheep. That's by definition livestock. Sometimes that area can be grayed, but that's obviously relevant. That we've got an allegation of inappropriate enclosures that could amount to neglect, mistreatment, cruelty. We've got an allegation of no food or water. It's important to note that issue of food and water in the scope of your authorities when there isn't food or water applies to all animals. In this case, it doesn't really matter if it's livestock or companion animals. It's any animal, which again is very broadly defined in statute. It's also important to note and keep in mind that this particular BAP agent is employed by a nonprofit entity. So the The easiest answer, the shortest answer is that yes, this BAP agent can go out there and, or using quotes, investigate. What they have authority to go out and do is provide food and water, and so that's the focus of what they will be doing. This line can kind of sometimes be unclear, and sometimes your role will change as you are engaging in whatever behavior or investigation you need to do. So, first of all, like I said, it matters that this animal is livestock in some settings. When it comes to entry and care, it doesn't matter. There's a definition of livestock in the statute. It's very specific, used in the farm or ranch production of food, fiber, or other products defined by the commissioner as ag products. It also, in that definition, lists certain animals, and certainly sheep is one of them. So the question is, you go out, again, for entry and care, for the food and water piece. When you are there, any observations that you make are still very important and still play a very important role. They sound a lot like you're investigating. You don't have the authority to investigate for cruelty, but again, they are still very important and will be relevant to other findings, for example, a finding of probable cause or PC. So if you go out and you observe that the enclosures happen to be, in fact, very dangerous, maybe there's broken boards or exposed nails, it's too small, you can see that because it's so small the animal can't lie down, it is in fact causing unnecessary pain and suffering, or a violation of 3542-109. You are not without options. Obviously, you can engage law enforcement. Again, make observations, document it. It will be relevant for a finding of probable cause or PC, and it can be relevant later on in the case. We'll get to that in a little bit. What you see in plain view when you go is also really important. You are able to act on what you observe, see, hear, smell, even without a warrant. So if you go in to provide food and water and you see in a neighboring enclosure that there are chickens that are clearly distressed, they have a very low, body condition score, which I think is actually hard to do with chickens, but you can tell that they're very, they're emaciated, they're much thinner than they should be. You can obviously at that point, again, provide food and water. You have that ability to enter and care under the statute. But you also have the ability to observe and then act upon that. So you can engage law enforcement, you can get a warrant if you need to. Same thing if you were to find evidence of a totally unrelated crime, like drug paraphernalia or manufacturing of drug, whatever it may be. The statute does not give you authority to investigate those either, but you can certainly engage law enforcement. You should still document it. You should still very much take note of any observations that you see. Sure.
So we have a lot of parks in my jurisdiction, backyard farms, and people just have these animals just because. So if they're not using them for the production of food or fiber, would that affect the direction in which the BAP agent can take that? Even though they are livestock animals, they're not keeping them for those purposes.
Yeah, it is. It's very relevant, and I think it's a case-by-case determination. Again, the statute lists certain species in it, and so sheep is one of them. I think there are times, too, when I know there's been a lot of situations with llamas where it's not as clear. But the question, and let me go back to the definition so I don't get it wrong. Used in the farm or ranch production of food, fiber, or other products defined by the commissioner as ag products. So the commissioner has defined, for example, sheep as an ag product. But the use is definitely relevant and should be considered. It's kind of a case-by-case basis. Sure. Thanks for the question. Okay, so same thing. Plain view, you're on scene originally to provide food and water, but what you are observing certainly is relevant. Your role potentially is changing, or is the question is, can it change? In this hypothetical, you are there and you hear an animal kicking a stock tank in a nearby barn. So you can't see it, but you can hear it, and you know from your training and expertise what the significance of that is. It's potentially, or even likely, another animal that doesn't have sufficient access to water. So what are you able to do? You want to take the analysis kind of one step at a time. I mean, if there's a gate or a fence between you and the barn, you can't approach it, not without a warrant. If there isn't and you're able to approach it, can you hear anything if you get close to it? Is there an open window that you can look in? Is there, cracks in the boards if it's a particularly dilapidated barn? Can you see in? So, it's a case-by-case analysis. Your safest bet, the fallback here is always to get a warrant. Engage law enforcement so that you're not exposed. You don't want to run the risk of gambling, whether or not this is a residence. When you enter and provide care in the term with food and water, you are not able to do it when it's a residence ever, unless you have consent or a warrant. And you always have to post. So keep that in mind, that you may not know if something actually is a residence. It's often unclear when it comes to like outbuildings or barns. You'd be very surprised at who's living in what and what it's being used for. And you oftentimes don't know that until you've gone in, and it's too late. So this is a pretty tricky one. Your safest bet is to get a warrant. Again, if you are going under the authority of providing food and water, that you can do that for any animal in any area or type of building, not if it's a residence. So, yeah, like I said, it's a case-by-case basis. Has anybody ever had a situation where it was kind of unclear if they could go in and provide food or water? We had a case relatively recently where one of the CDA agents went into a property to provide food and water. They needed to get food to those animals right away. It was a very remote, rural part of the state. And so it was going to take quite a bit to leave, go find whatever feed was necessary at whatever resource, and then bring it back. Oftentimes it's true too, we go out to properties and they don't actually have access to running water, so same thing. And there was a question because there was a barn, and there was also a wagon, like a big, I guess a trailer, I should say trailer. But it had a tarp over it. It was concealed, what was underneath it. It definitely looked like the shape of hay. It smelled like hay. They were pretty sure if they just lifted up the tarp, there'd be hay there. They could then give it to the animals. Problem is, you can't lift up the tarp without a warrant. That was my legal advice anyway. So there are some potential pitfalls here. You cannot walk around like opening cabinets trying to find food or water. It generally is going to require that you leave, go do that, and come back, even though that's incredibly inconvenient and maybe not very efficient. So kind of the next turn on this hypothetical, agent decides to in fact go in. They can determine from the outside that it's not a residence. Maybe there's an open window they can look in. They can see that there are animals in there. They in fact don't have food and water. So the agent goes in. What they see when they get in there is that there are sheep confined without access to food and water. They also notice that these sheep are emaciated. Maybe one has an injured leg. So again, we're bringing into the forefront the possibility of a cruelty case, in addition to just being there to provide entry and care. So at that point, what can the BAP agent do? Same thing. We know these sheep are livestock, so we are limited. What you observe in terms of plain view is still very relevant. Go ahead and provide the sheep with food and water. You want to make as many observations as you can. Again, if they have a particular response to the food and water. If they drink vigorously, like they've been deprived, that's certainly relevant. Same thing with food. If you've got a camera there, go ahead and take a picture. I would not advise that you leave the scene to go get a camera or a video and then come back, but you can certainly observe whatever you need to observe, photograph whatever you need to photograph, and you can write down notes. I wouldn't write your full report there, but you can certainly take some shorthand notes. And there's been some kind of gray area for us in terms of when you're doing that, if you can, for example, palpitate an animal. And I think it's really, it's kind of a hard one. I think this can be a slippery slope. Generally speaking, no, you cannot palpitate the animal. That's related to an investigation of cruelty. But if you needed to put down, a bucket of water and move the animal aside when you're doing that and you feel the bony prominences, that's certainly relevant, and you would want to document that and record that. But you can't open cabinet doors, look in other enclosures, anything that's outside of what you need to do to provide that immediate food and water would be outside the scope of what you have authority to do. When in doubt, obviously, engage local law enforcement, call the BAP program. We're happy to help. It's imperative that you would not free the animals from the binding. So either, taking them off if they're harnessed or haltered, or opening the enclosure, letting them out. It can be very tempting, I'm sure, if the animal is clearly suffering and you are just expected to stand there and wait, but that unfortunately is what has to happen. There'd be significant liability potentially there. Again, always be mindful of the changing role. You are not the one that can write the report or collect the evidence, but your observations can form the basis of probable cause or PC. You have expertise that I imagine a lot of times law enforcement doesn't, depending on where you are and who you're working with. So you may have knowledge of species that others don't have. You can help weigh in on what samples should be taken, what evidence should be taken, what to photograph, how to transport and load, animals. That to me is generally speaking a very nuanced thing, and you're going to need a little expertise in that, which you all have, especially if the animals are injured. You can also assist in veterinary involvement, getting a vet involved, and what steps need to be taken to bring that vet up to speed. So the difference between civil and criminal cases, they generally speaking have a lot of similarities, but there are a few key differences. Both provide for complete investigations, both have warrant authority. A civil case has a few more options or tools for enforcement that are, stop just short of an actual conviction or an actual filing of civil liability. Civil remedies include a cease and desist order, oftentimes referred to as a CDO, which is just a court order saying, stop doing what you're doing. It comes from the commissioner. It has the authority of a court order, but it just says, stop doing whatever you're doing, or do something affirmative, take an affirmative step to do something so that you are in compliance. And again, this usually relates to 3542-109. Similarly, we have the injunctive relief as a tool. That is a court order that comes from a judge, not the commissioner. Same thing, it's telling somebody to stop doing something or do something affirmative to be brought into compliance. In short, stop committing mistreatment, neglect, cruelty, whatever it is. It has a much heavier hammer. Once we have an injunction, and they can be temporary or preliminary, or they can be permanent. But once we have one in place and somebody violates it again, there are far greater remedies, including punitive sanctions like jail. Both have the ability to remove animals, although the outcomes and the requirements to do so are a little bit different. A civil case requires a prompt hearing on fitness, and a criminal case requires a prompt hearing on cost of care and probable cause, or PCs. The remedies can also be similar. I do find it's much easier to customize our remedies in a civil case. So again, if we're asking the judge to, for example, issue a permanent injunction, we usually write that injunction ourselves and submit it to the court as a proposed order. So we can really be specific about, we want this person to get farrier care this often, or to bring out a vet to formulate this kind of a nutrition plan, and really kind of get into the weeds in a way that a criminal case cannot. I also find that there's a little bit more oversight. Once a CDO is in place or an injunction's in place, usually local law enforcement knows about it, you all know about it, you can go out anytime and ensure there's compliance. In a criminal case, that's not usually what happens. If somebody is sentenced to probation, they may have a probation officer. That probation officer has likely little to no experience in what's happening, and is much less likely to be able to kind of follow up and make sure that whatever needs to happen to bring them into compliance is in fact happening. Something else to kind of consider or keep in mind is that criminal violations or convictions will follow somebody much longer, their lifetime, and in further places. So if they leave the state and they go someplace else with their animals, and they're still doing the same activity or behavior in another state, that state investigates it, they can look it up and see that it happened in Colorado. That's very persuasive and certainly can actually help in the case in another state. That's not really true with civil cases. So if somebody has an injunction here, they just leave the state and go continue committing whatever behavior in another state. There's really not an effective or efficient way for the other state to search and see what happened in Colorado. So important things to keep in mind when deciding whether to take civil action, criminal action. And again, they're not exclusive. You can certainly do both, and oftentimes that is the best answer. When it comes to civil actions against livestock, what is important to note here is that even the commissioner has no authority to take livestock. The commissioner has to first petition a court to get authority, and then once it has that court order, then he or she can act. This is the court acting to ensure that reasonable grounds exist to establish that livestock are in fact being mistreated, neglected, or abandoned, such that their life or health is endangered before any action is taken. The statute requires a prompt hearing, and again, the purpose of this hearing is to ensure timely due process. The only difference for companion animals is that the commissioner does not need an order of the court. The commissioner can make the determination to remove companion animals on the commissioner's own authority, and can work with PACFA and or other community resources to get that goal accomplished. Similarly, there's a requirement that there be a prompt hearing to determine fitness of ownership. What triggers a court hearing is anytime the government, in this case the commissioner, deprives a person of property. And animals are property, they do have value. At the time of a hearing to determine an owner's fitness, the court must answer really two questions. Is the person able to adequately provide for the animal? And is the person fit to own the animal? At this hearing, the court makes absolutely no determination about other animals or future ownership. So while there may be a finding that that person is not fit to own the 3 or 4 horses in question, that maybe doesn't apply to horses, the remaining horses on their property, or they've got horses on a totally different property. Keep in mind that only the attorney statutorily authorized to represent the Commissioner of Ag is the Attorney General, and that's the only attorney that can take action on these types of cases and represent the Commissioner in court on either a fitness to own hearing. So what are the elements to prove that somebody's able to inadequately provide for the animal? Lack of feed, lack of water, lack of shelter, actually having animals that are dying or dead from starvation or dehydration, any kind of lack of ordinary vet care. What's needed to prove that somebody's not fit to own the animal? They're incapable of understanding the specific needs of a species. There are consistent or ongoing examples of mistreatment, neglect, or abandonment, and or some sort of mental or physical infirmity, which I feel like we see a lot, frankly, is people who are just, for whatever reason, either because their physical abilities are limited or situations just gotten kind of out of control. They were well-intended, but maybe the animals reproduced. Suddenly there's too many, the weather changed, but it's not unusual for somebody to quickly just kind of be in a situation where it's gotten out of their hands, out of control. One of the commissioner's civil enforcement options is a cease and desist order. So the commissioner has several non-delegable authorities, and your role in using or utilizing these tools alongside the department can be an important part of what you do. Like I said, a CDO, which is a cease and desist order, is an order of the commissioner. The purpose is to provide notice to an individual to cease and desist from committing or failing to perform any action that violates the act. It does not require a hearing. The commissioner can make the decision to issue a cease and desist order, and it can go out later that afternoon. We almost always want those served personally. It doesn't have to be a professional process server, but we want somebody who can go on record in the future and say, I had it in hand and I put it in his or her hand. That's required because in the future it can be a defense that they didn't know about the cease and desist order. They never saw it, never had it. So we almost always elicit some sort of a personal service to get that served. It does not require a trial either before or after the cease and desist order issues, and it does not involve state court. Somebody can challenge a cease and desist order. We'll get to that in the next slide, but that's done in the Office of Administrative Courts, so it's not in the state courts. It's a completely different system. CDOs are permanent. The elements of a CDO requires that the commissioner have reasonable cause to believe that a violation has occurred. That's not a very high burden. It's certainly not like beyond a reasonable doubt, which is what they have in criminal cases. So it's usually pretty easy to establish reasonable cause. It's pretty easy to establish that immediate enforcement is necessary. That's true anytime there was a violation of the act. It also orders a person to cease violating any provision of the act. The actual elements of the cease and desist order itself requires that the provisions of the act alleged to have been violated include facts alleged to have constituted the violation, and a very simple requirement that all action causing the violation be ceased. Again, a CDO is permanent in nature. It stays in the books forever, unless an agency seeks to withdraw it, which I've never seen or heard about. I'm not sure why or under what grounds it would be withdrawn. As I mentioned, it does trigger a right to a hearing, so somebody can challenge it after the fact. That's an administrative court as opposed to state district court. Usually, well, under the statute, there is a requirement that somebody who has received a cease and desist order become compliant in 24 hours. That's not something that we always enforce. Sometimes it's not realistic to get somebody in compliance within 24 hours, and or it's in the best interests of the animals if we take more time potentially to get them moved. So that's kind of a fact-specific situation. But generally speaking, it's 24 hours for compliance. Thereafter, if somebody does not comply, there are additional remedies that the department can take. Primarily, it's getting an injunction, but not necessarily. Sometimes a cease and desist order is a good tool just to lay the foundation of somebody engaging in behavior continually or ongoing. That's a pattern of misbehavior. And that's an important thing to keep in mind. Again, if somebody does not immediately comply, we do have authority to act or take it to the next level, and that's seeking an injunction. An injunction is a court order. It comes from the judge as opposed to the commissioner. And really, it's the same thing. It's saying stop doing something or start doing something, whatever needs to happen to get into compliance with the act. It requires sufficient evidence satisfactory to the commissioner. So in some ways, I think this is actually a lower bar than there is for CDO. There's certainly a reasonable element to it, but sufficient evidence satisfactory to the commissioner is pretty subjective. And it's really up to the commissioner as to what that's going to look like. It's got to be a finding that a person has engaged in or is about to engage in, which I love that second part of that provision because it really opens the floor. It doesn't have to be something that's even happened yet, but if the groundwork is there and we are anticipating a violation of the act, specifically probably 109, we don't have to wait for it to happen. You can seek an injunction before that. And again, it's any act or practice that constitutes a violation of really anything in Article 42. The elements require that we name a party. It has to be a specific individual that we are enjoining or putting the injunction against. Sometimes that's kind of hard. We've had situations before where it's not entirely clear who owns the animals that are in need of care. We've had situations where people who are otherwise transient are living out of a car and kind of keeping their property or keeping their animals at somebody else's property. Maybe that person's also involved. It's not always entirely clear. So it's important before we file for injunction that we know who the parties are and who the parties are not. Jurisdiction of court is usually just where it's happening. So where these animals are kept, where the violations are occurring. And obviously we need to detail the allegations. We need facts to support any allegations. It's also important to note that it's only the commissioner who can exercise the authority to seek an injunction, and only the commissioner's statutory counsel who can represent the commissioner in a court of law on something like this. So it would never be like a local DA's office, for example. The effect of a civil suit for injunctive relief. The first step is to obtain a temporary restraining order. There's essentially a lot of terms or words for the same thing. A temporary restraining order is temporary, and it's an order from the court saying, don't do this or start doing this. Get in compliance with the act. It's filed ex parte, which means we go into court by ourselves and say, Judge, this is happening. We need you to sign this order. The other party isn't there. So the animal owner or the person that we're trying to get an injunction against isn't there. They don't get to weigh in. It's done very quickly. We usually get it within the same day, certainly within 24 hours or the next day. It's because it's ex parte, it only lasts for 14 days. So when we file this and we get an injunction, we ask that everything be expedited, and it's the same effect as pulling a fire alarm. We have to move very quickly. We have to make sure our evidence is already compiled and ready to go, reports have been written, pictures have been downloaded and identified, whatever other evidence we have. The next step is that preliminary injunction. It's pretty much the same thing as a temporary restraining order. Again, same, different terms for the same thing, same concept. Another order from the court saying, stop doing something or start doing something to be brought into compliance. It essentially takes over or replaces the temporary restraining order once it expires at that 14-day mark. So there is an evidentiary hearing. The burden is low, reasonable likelihood of success on the merits of the complaint. But we pull witnesses in, we have people testify, we admit exhibits, pictures, all the things, which again, we should have had already ready to go. Because at this point, the animal owner is there, has an opportunity to present a defense, and evidence has been admitted, this preliminary injunction does not have the same short expiration date as the TRO, or the temporary restraining order. So it goes into place and stays into place until a hearing on a permanent injunction, which can be weeks out, it can be months out, depends a little bit on the court's schedule. But the goal eventually is a permanent injunction or a permanent order from the court saying, get into compliance, you have to be in compliance. The temporary restraining order or the preliminary injunction are the steps that we take to get there. The goal is to protect the status quo. So until we can go to trial, have a full trial on the merits, we can protect the animals in question and keep the violations from continuing to occur. Again, the goal with a permanent injunction is that it be permanent, that we get to that third stage, TRO, preliminary, and permanent. So it enters after a full trial. Both parties will have had the opportunity to provide all the evidence in support of their positions, make any arguments they want, call any witnesses they want. If the court does order a permanent injunction, the terms must be very specific. So we can't simply say, we want this person to be permanently enjoined from violating the act or committing any kind of cruelty. It has to be very specific in terms of, denying food and water to animals or denying vet care, very specific terms. Changed circumstances over time can result in a court's determination that an injunction be amended or lifted. So unlike a CDO, which again, I can't imagine a circumstances where we would ever withdraw it or pull it, that can happen with an injunction. The benefit of an injunction as opposed to a cease and desist order is that it has potential for pretty heavy consequences. So if somebody violates an injunction once it's in place, we can seek contempt of court, which has punitive sanctions associated with it, including potentially jail. So there are times when somebody has established that they have been rehabilitated, circumstances have changed for whatever reason, and the injunction can be lifted. So all in all, the remedies or the options here are removal, and what comes with that is a fitness of ownership, a cease and desist order, or a civil suit for injunctive relief. These remedies can often be used together. You can just use one, you can use both, they are not exclusive. They often work together. We've certainly had circumstances where we felt like it was prudent to start with a cease and desist order, and depending on the results of that, then either escalate to an injunction or not, and or a removal or not. We can file a cease and desist order first or after. The order is also not particularly relevant. The Colorado Open Records Act, often referred to as CORA, does apply. It holds that the public policy of the state and that all public records shall be open to the public for inspection by any person at reasonable times. It's very, very broad. So CORA defines any kind of a public record as a writing. It's all books, papers, maps, photographs, cards. It can also be recordings, whether audio recordings, video recordings, pretty much anything that you collect or that you encompass as part of your investigation, you should assume will be held open to the public. This core statute is enormous and frankly not very well written. There's a whole host of exceptions or possibilities for withholding a record, either in its entirety or simply redacting portions of it. I won't get into those exceptions because it's a rabbit hole, but for your purposes, you should assume that everything that you create, everything that you have, will be made public. When a CORA request comes in, there's a very short timeline. So we need you all to notify us immediately. We will then look at it, and if a privilege can apply and there's grounds to withhold something, we will do that at that time. What's most important, though, is that you are aware that your records are subject to QORA. Agents commissioned by the Commissioner of Ag are an extension of the Commissioner, and the results of their investigations are subject to the Open Records Act. It is not sufficient to say to a reporter or a requester that the records are the property of an entity that is non-governmental. To the contrary, the records were established and are maintained to fulfill the purposes of the Act, and are therefore very much subject to QORA. Agents who are working for law enforcement are subject to criminal justice records requirements as well, and that's a little different than the regular QORA, or Open Records Act. But agents who are working for nonprofit entities are operating exclusively as the Commissioner of Ag, and therefore are subject to QORA. So if you were working for a law enforcement agency, you'll want to make sure that you notify your supervisors as well. I'm sure there's a person designated for records requests. You also have a short timeline, so make sure that you notify all relevant parties as quickly as possible. As I said, when you get one, go ahead and forward it to CDA. Again, there's a huge list of exceptions, but generally speaking, we need to turn around a request in 3 business days, which is really fast. It's 3 business days from the time that it's received, not necessarily the time that you open the email or you find the request. So, I can't emphasize that enough. We got to move really quickly with these. Like I said, just forward it on to the department. They will work with counsel to determine what, if anything, needs to be turned over. For the purposes of what you do day in and day out, just assume that everything that you have is open to the public. There's a dangerous dog registry under 3542-115. It's maintained at the department. After conviction of unlawful ownership of a dangerous dog, the convicted individual must permanently identify the dog by having it microchipped by either a licensed vet or a licensed shelter. It's a useful tool to check for reports or records of dangerous dogs in the state, but do be aware that it's not wholly comprehensive. It's just a starting point and not a be-all, end-all repository of information. And obviously, what's in this registry is subject to open records. It may be useful for you to do a search. If you ever need help with that, just let us know. And that's it. Are there any questions or any areas that you all want to delve into, bring up? Because it's either unclear or you see it a lot.
So one of the slides that said that you guys can do it when a violation has occurred or likely to occur. I don't remember how many times you have knowledge that it might occur. When do you use something for something that might occur in the future? I guess I'm just kind of confused on that part.
Yeah. So I think that was in relation to seeking an injunction. So I think we can get an injunction if there has been a violation or, yes, about to be. The commissioners determine that there's about to be a violation. If you find evidence that somebody is setting up an animal fight, for example, now you'd probably want to do more than one remedy, but one option, one tool you would have would be to get an injunction against animal fighting. I have so many PACFA cases, all my examples are kind of PACFA related, but technically this, I think, will still be illustrative, so I'll share it with you anyway. We've got a rescue that's operating when it shouldn't be. So it's, in theory, rescuing dogs. They're claiming to rescue dogs. The person has a tendency to hoard the dogs in her home. That's happened continuously in the past. We went out most recently on a warrant, and she's actually constructed outbuildings on her property that are like wall-to-wall kennels. No dogs in them yet, but she's clearly going to continue hoarding. So we would get an injunction saying, do not hoard. And what we would tell the judge is, we talk about what's happened in the past, the other instances that she's hoarded dogs in her home, and we would also admit evidence related to these affirmative steps that she's taking to keep doing it or to do it on even a higher level. Does that make sense?
So do you need like a previous history in order to do that? So like if I get a complaint like there could possibly be dog fighting at this residence, we go and we see just like kennels, chains, like workout equipment, but no dogs, we have no prior history. Is that something that we can still do even though we have no actual violation?
It's very fact specific. Technically, yes, because all the commissioner needs to seek an injunction is that somebody's about to violate a provision of the act, about to engage in cruelty or neglect or fighting. So it's pretty fact specific. I think they could easily defend themselves by saying, oh, no, we have chains for all these other reasons, or we have, these rings or pens where the fighting was going to occur for all these other reasons. And so we may be going to court with not a very strong case. But there could be ways for us to bolster that evidence a little bit. I mean, if somebody was starting to place bets or had posted something on social media about it coming up, probably they aren't that dumb, but we'd want to really delve into the facts and the evidence specifically. Under the law, you can seek an injunction, but we may not have the strongest case at that point. We may want to wait and see if we can't gather just a little bit more evidence.
I have a question. If a criminal, excuse me, if a criminal investigation and a civil investigation are occurring concurrently, and the criminal case ends up in charges and the civil case ends up in injunction, have you ever had an issue of that falling into double jeopardy, or does double jeopardy only really apply in a criminal standpoint?
Yeah, there wouldn't be a double jeopardy issue. That's just a criminal. So if somebody is convicted in a criminal court or not, it does not affect what we can do civilly. So if somebody's convicted, we can get an injunction. If somebody's acquitted and a jury says they didn't do it, we can still get an injunction or cease and desist order or do whatever we want. They're definitely siloed. It can be complicated, I think, when there are essentially companion civil and criminal cases, because when somebody testifies in court, what they say can be used against them in the criminal case. So there can be a timing issue. You want to make sure that, frankly, the criminal case goes first. The criminal cases generally take longer, so I guess just be mindful of that timing. And whoever's prosecuting the criminal case can certainly help with that. Anything else? Okay, thank you very much for your time.